I'm going to reveal 10 huge mistakes people with personal injury claims make. These mistakes often result in your getting a small settlement. If you avoid these mistakes, you may get a much faster and larger payout. To expose the first mistake, let's look at what insurance companies know about your past claims. They can quickly find out about all your past claims. In personal injury cases, all insurance companies have access to the ISO. It shows them every claim you've ever made. You may think you're hiding your past claims from the adjuster, but I assure you, you are not. There's a sneaky reason why insurance adjusters ask you for your date of birth, your address, and your full name. It's so they can run a claim search on you and see all your past claims. It takes them just seconds to run this search. And if you try to hide your claims, it can be a devastating blow to your case. The adjuster won't ever trust you and may pay you much less as a result. So the first mistake is not realizing that insurance companies know about all your past claims. This second mistake can cost you big money in your case. When you're done getting your medical treatment, you are usually ready to try to settle your case. This is because you know exactly what treatment you've had and its cost. And just as important, your doctor has a very good idea of what treatment you'll need in the future. You also should know how much your pain and suffering is worth. When you're done with your treatment, your doctor can say how much your future medical treatment will cost. When negotiating with insurance companies, consider a Harvard study that found something fascinating. Negotiators who made the first offer felt more anxiety and as a result were less satisfied with the outcome. It's best to ask the insurance company to make you a fair offer. Hopefully you'll get an offer that is much higher than you expect. That said, I found that many people settle for way too little, even when the insurance company makes the first offer. They either undervalue their pain and suffering or they don't provide the insurance company with all their medical bills and records. And they often don't know how to get paid for their future pain and suffering and future medical expenses. The only time that I usually recommend demanding a certain amount to settle for is when the following happens. It's when the other party has a limited amount of insurance and your injuries are worth more than that amount. In that instance, you may be better off asking for a certain amount, which would usually be the insurance limits. However, before accepting the insurance limits, you may want to first see if the driver can afford to pay you above the insurance policy. For example, I recently represented Aaron, who was riding a bike when a car hit him. Aaron injured his back. In this instance, I didn't ask the insurance company for a fair offer because Aaron's case was worth more than the driver's $100,000 in insurance coverage. However, I got the driver to personally pay $15,000 above their $100,000 policy limit. But in most cases, I recommend asking the insurance company for a fair offer. Otherwise, you may make a demand that is way too low. And once you've made a low demand, the insurance adjuster is going to permanently write in their notes that amount, and they may never offer you more than that amount. There's an exception to this rule, though. If your injuries get much worse, they may offer you more than your first demand. For example, let's say that you get surgery. Even if you already asked for a low settlement amount, they may offer you above that. The reason is because the full value of your case has gone up. So the second mistake is to ask the insurance company for a certain amount of money before they've made you an offer. The solution is to simply ask the insurance company to make you a fair offer. The third mistake that may destroy your settlement is to fall into one of the many insurance adjuster traps. And Ellie's recent case gives the perfect example of this. She was a passenger in a car being driven by a friend, Jason. Jason was speeding and they crashed with the van. Ellie's leg struck the inside of the car and she broke it. Ellie hired me. The insurance company for the van didn't offer a penny. The defense lawyer said their client, the van driver, did nothing wrong. Finally, I got them to offer $25,000 and then $50,000. What did you think when I got the van's insurance company to offer $50,000 to settle?
I was very happy, very happy. We went from nothing to 50, which was definitely a start. I started seeing bright colors at that point. I said, okay, now we're getting somewhere. And okay, so I saw, some hope. I really did. We went from nothing to something.
The defense lawyer then told me that I'd need to drop my demand below $100,000 for them to make an offer. I called their bluff. I told them Ellie needed much more than $100,000. Eventually, we settled for $100,000 with the van's insurance company, but that was because I didn't fall for a common adjuster trap. If I had dropped our settlement demand below $100,000, they'd have likely tried to get us to settle for an amount close to $50,000. Don't let the insurance company control the negotiation. They often use clever tactics to try to get you to settle for cheap. This next mistake often results in small personal injury settlements. Sometimes your doctor will say that you'll need future treatment or surgery. If they do, ask them to estimate how much this will cost. Then send the estimate to the insurance company. In a car accident case, the surgeon said that my client may need surgery to his leg. I asked the doctor for a written estimate and sent it to the insurance company. I got them to increase their offer by over $84,000. So getting the doctor's office to write an estimate may be an excellent use of your time. Don't always believe the insurance adjuster. You often want to give them what they ask you for, but not always. In fact, giving them everything they ask for can destroy your case. For example, let's assume a driver causes your injury or you slip or trip and fall somewhere. The adjuster may try to get you to give them your recorded version of what happened, but you usually aren't required to give a recorded statement to the other person's insurance company. I've seen many people say things that killed their case. It often happens when you're describing how the accident happened to the insurance company. They're allowed to use your statements and emails against you, and they'll often do so to try to pay you less. This next mistake can really delay your settlement or result in you getting a small payout. I know it's frustrating to get a low offer from an insurance company. I've had it happen more times than I'd like to admit. Some people think that to win your case, you must be aggressive, maybe even yelling at the insurance adjuster as if that would force them to see things your way.
Colonel Jessup, did you order the code red?
Yelling worked in that movie scene, but in real life, especially when dealing with an insurance adjuster, it won't help your case. You may be thinking, if I'm nice to the insurance adjuster, that means I'm weak. That's wrong thinking. You want the adjuster to be relaxed when dealing with you. I've had many relaxed conversations with a claims adjuster where they told me something game-changing that helped my client's case. In one case, my client broke her arm in an accident and had surgery. I thought we were going to have a hard time proving the business was liable. The adjuster was relaxed when dealing with me. He then told me that the photos that he had were bad for his case. It was great to hear that. We ultimately settled for $240,000. Instead, it's crucial to treat the adjuster with respect and approach the situation calmly. If you can't settle with them, you can still sue. The next mistake can really make your settlement much smaller. Sometimes the insurance adjuster will call you to ask you a few things. They want to know if you're still going to the doctor for treatment related to the accident. They may also ask you when you're going to send them your medical records and bills. They're asking this so they can avoid surprises later. The last thing an insurance company wants is to find out you've had a lot of medical treatment that they don't know about. This can delay your settlement because it takes time for them to get approval to pay you. Insurance companies have to set aside a certain amount of money to pay your case. This amount could be zero to a large amount. Sometimes unexpected medical developments occur, such as you needing surgery. But the insurance company wants to know what's going on right away. The last thing they want to hear is that you've had 2 surgeries since they last spoke with you. That would likely make them set aside a lot more money. They could have planned better if they had known about your first surgery early on. So it's important to keep the insurance company updated on your medical treatment. It may allow you to get paid much faster. Many injured people think that if they just tell the insurance company they're in pain, they'll get paid. They won't. This is a big mistake that happens all the time. Make sure you send the insurance company your medical records and bills. Don't think that telling them that you're in pain will get you paid. Your medical records are 10 times more important than just telling the adjuster that you're in pain. Mistake number 8 may lead to a small personal injury settlement. It can be a huge problem because the insurance company often argues that your accident didn't cause your injury, especially if you're claiming that the crash caused pain in your neck, back, shoulder, or another body part. The mistake is not writing down the type of accident on the doctor's new patient questionnaire. For example, if you were in a car accident, write that down. Also, after your first visit with the doctor, request your medical records to confirm that they say the cause of your accident. You don't want the insurance company to later claim that your treatment was not due to your accident. The last thing you want is to have to ask your doctor to correct your medical records. So write down the cause of your accident at your first doctor's appointment on the new patient forms. This next mistake can greatly delay you getting paid. Once you reach a settlement, you may need to pay back your health insurance company for what they paid. The same is true if the MedPay coverage on your car insurance pays your medical bills. The problem with this mistake that I'm going to mention is that your health insurance may not pay your bills if your car insurance isn't billed first. It's frustrating to have a large settlement, but the hospital or doctor's bill is still massive because they haven't billed both your car and your health insurance. The big mistake is not giving both your auto and your health insurance to the hospital and doctors. Before you settle your case, you want to know how much your health insurance company has paid the hospital and all your doctors. This is so you know how much the careless person owes you, and so you know how much you may need to pay back your health insurance company. There's also time limits for the hospital and doctors to bill your health insurance company. If your health insurance company gets the bills too late, they can deny payment, which is horrible for your case because you'll owe more medical bills from your settlement, and you don't want that. And you could have easily avoided this. To reveal the next mistake, let's assume you've learned just a bit about how personal injury claims work. Maybe you've watched a few videos or read some articles. Because you know a few things, you might feel like you understand everything about handling an injury claim. This feeling is called the Dunning-Kruger effect. The Dunning-Kruger effect happens when people who know a little bit about something think they know a lot more than they actually do. In reality, injury claims are complicated, and there are many details that only experienced lawyers understand. When someone feels overconfident about their knowledge of injury claims, they might make mistakes like not knowing what information to gather, not understanding how to deal with insurance companies, or missing important deadlines that can kill a case. That's why it's important to realize that knowing a little bit about personal injury claims doesn't make you an expert. Having an experienced lawyer on your side can make sure everything is done right and that you get the best outcome for your claim. The final mistake is not at least speaking with an attorney to see if they can help you. What I didn't tell you is that I used a simple trick to help get my clients a big settlement in my cases that I mentioned. And the best part is that anyone can use this straightforward tactic. To find out what the trick is, watch the video that's on screen now or linked in the description below. And if you've been injured in a car accident in Florida and you think that someone else may be at fault, click the link in the description below to see if I could be the lawyer for you.